Hey everyone, it's Rob Ryder. It's Wednesday, May 9th, 2013, and continuing on with trying to do simple complaints, mainly looking for the right office more than spend a lot of time writing something that nobody's going to pay attention to. It comes down to finding justice. We're in courts of law, we're looking for the court of justice, which will be the court of equity, and it's where you'll get your equitable remedy. Because unfortunately, right now, you don't hold the legal title to anything. Somebody else is holding the legal title. Or they're claiming they're holding the legal title, and that you've given it to them as a gift on a unilateral contract, which could be used for a gift or donation, but certainly not for equal consideration. And that's what we haven't seen yet, is equal consideration to our promise that we've put on paperwork that they haven't promised in like, nor have they provided any consideration of any kind. So one of the things that, again, that brought this about is what a county clerk told Roe in Illinois, was that the chief judge of the county has jurisdiction over all the property in the county. Well, to me that means that the chief judge is the one who's going to determine who the owner is and who should have possession of the legal title. And that right now, not necessarily in their office, but under their office, is where all the legal titles are. And so when somebody goes to the drawer today to say who has legal title to your property, when they look in it, it doesn't show that you are. It shows somebody else. Well, the record shows what it shows, and in law, whatever the record shows is the law. And the only way to change that is to go to equity to say, well, maybe it's in there that way, but it would be fraudulent because they didn't do this, or this, or this, or misleading statements, or whatever it was. So what we're trying to do is get an in personam hearing and get out of in rem and get an in personam, mano a mano, to determine which one of us is the false accuser. So I guess the way you would start it is honorable, whatever their name is, and then whatever their title is. And you might even put care of whatever court it is. But, you know, their name and their title. And then in the matter of, which is an ex parte hearing, is something that is in the matter of. And it's in the matter of you and your property. Now, whether you like it or not, they gave you a true real name, which is your last name coupled with your given name and initials, such as if you're a junior, JR, senior, SR. Those would be the initials. But your true real name is your last name coupled with your given name, where your real name, not your true name, but your, I think they call it your real full name, is your last name coupled with your first name and initial. And we have one of those also, right? Sometimes mail comes to Ritluski Robert A. I don't see very much mail for Ritluski Robert Allen, which is what my true name is, which I believe that they use to mail the real documents that are of great importance to you. That's the name they put on it, and that name's got an address that I don't know, so I never get the mail. They're doing it on postcards, in my opinion, that don't have a place for a return address, so now they can't be returned, and they just go to lost mail. But I'm sure you've all noticed by now that everything that you get in the mail has been scanned. It's got a barcode on it. They can find any piece of paper ever. It's just the way the system works now. So anyways, if it's joint owners, it would be both of you. If it's just one, it would just be one. And then, and my or our property, right? In the matter of Ritluski Robert Allen and my property. Honorable Magistrate, I accept your oath to the solemn office of magistracy, bind you to it, remind you of your duty to see that justice is fairly and quickly found, all men being equal under God's law. Pretty simple. I'm going to accept her oath, his or her oath, and the office they hold is the office of magistracy. It's one of the two sons of oil. One of the candlesticks in the Bible in Revelations. Magistracy and ministry. And they're holding the office of magistracy. And it's a divinely appointed office because a civil authority is divinely appointed. Who else is going to adjudicate the differences? Who do you take the false accuser to? This sworn complaint is to make your conscience aware that a simulated legal process is now proceeding as an in rem legal action, the result of which would be a willfully false judgment and perjury of conspiratorial witnesses coveting our property and attempting to unjustly enrich themselves by the form of legalism. So they're using legalism against you, which is, what all these statutes are. It's just legalism. Apparently God didn't do a good enough job in his 10 commandments, and some man thought he had to write some more for you. And so now you have all these statutes and codes and ordinances and rules and regulations and so forth. And if you decide those apply to you, well, they're happy to have you. But when they use those, they're making a willfully false judgment because nobody has put anything under oath. By willful lack of execution of a bilateral contract, fraudulent claims of a security being a promissory note, errors and omissions resulting in improper recordings, concealment of legal titles, false and misleading statements, breach of fiduciary duties, incomplete closing of purchase agreements, mail fraud, threat, coercion, duress, contempt of court, and other nefarious means they attempt to perpetrate their fraud and swindle. I think that pretty much covers it. Right? They never, this bilateral contract, this first little part, I'm talking about the deed of trust or the mortgage, right? You signed it, they never did. Right? So it's a unexecuted bilateral contract that they're using as a unilateral contract to say, well, you gave it to us. Here, we got your signature. Right? All they care about is, well, is that your signature on the deed of trust? It looks like a unilateral contract to me. They never tell you that. That's the false and misleading part. They say that the thing they call a promissory note, they call it a promissory note, but it has a maturation greater than 9 months, so by definition, it is a security. I think that's 15 U.S.C. 78 C 10, I believe is the definition for that. Errors and omissions resulting in improper recordings, and this is just all over the place. For instance, if you, let's say one of the covenants, or what's the word I'm looking for? Encumbrances, there we go. On your warranty deed may be that you're part of a homeowners association. So if you were to go find this homeowner association recording, you might find that it's a 50-page document. But when you look at the front page where they put the recording information, it says 1 of 1. Well, that means all that was recorded was the front page. 1 of 1, period. Anybody that I've talked to who's ever had a multiple page recording done for them, it always says 1 of 3, 1 of 7, whatever it is on the front. On the homeowners association that Bobby in Arizona was part of, when we looked in his, it says 1 of 1, and it's a 50-page document. It's an error, right? Until you point it out to them, and if they don't fix it, well, now it's on a mission. That's fraud. So we got to point out the error, and if they don't fix it, well, then they're admitting to the fraud. Concealment of legal titles, right? We're looking for, depending on if you're in a Torrens system, you should have an owner certificate of title. You should be able to walk into an office and say, I want to see the original certificate of title for your land, and walk in and see your name on it, and on there would be any liens or encumbrances against your property. If they're not listed there, they don't exist. That's what it means about going into the office of the recorder, and whatever the record says is the law. Right now, you walk in there, your name isn't on that damn piece of paper. It's the guy before you. My opinion. They're always one behind. Somebody's holding your paperwork because the closing never happened, and it still has the other guy in there. If you're in an abstract state, it's called an abstract title. And again, it should have come to you at the closing. It's the legal title to the property. And on it would be listed any liens or encumbrances. Well, they don't want to show those, right? They're concealing them. False and misleading statements all over the place. Breach of fiduciary duties. We'll see that has to do with your insurance, your title insurance. Incomplete closing of purchase agreements, which is what the closing agent has done. He's never completed the closing, right? That's, you point out the error early and see their last. What started at the closing, it's never been closed. The contract has never been executed. Mail fraud, obviously, because they send stuff into your all capital letter name, or they send it to your name with just an initial, whatever it is. That's a fictitious name. To send mail to a fictitious name is fraud. To do it to commit fraud is fraud and swindles. That has a 30-year prison sentence on it. And, of course, we know they use threat, coercion, and duress. And they're in contempt of court. And other nefarious means they attempt to perpetrate their fraud and swindle. They'll pretty much do whatever they need to do to take your property. They want it so bad. They have to have it. It's a debt society. They have to create the debt. And they do that so they take your property. The fictitious proceeding under, and this would be, your case number if you're in a foreclosure and what court it's in. Now, you don't necessarily have to be in a foreclosure to do this, or you could have already lost your foreclosure. Nevertheless, there's elements in this that you could use for any one of them, and I don't have to sit there and write it down for each particular one. Just got to think about what yours is and how you might be able to use this, if you decide to. So, the fictitious proceeding under case number in whatever the court is has our properties as the fictitious defendant, of which we claim paramount rights, title, and interest. Errors or omissions of records to the contrary notwithstanding. This proceeding under the control of probable usurpers of public office lacks any sworn testimony to substantiate plaintiff's claims, allows false and misleading statements to stand as truth, and enables, without just cause, fraudulent claims to be enforced by courts of incompetent jurisdiction. Right? You're in a fake court, doesn't use any court seals, nobody signs anything. It's all done willy-nilly. It's definitely not done due form of law. Officers of, this is to the title insurance company now, you would put them in here, having a duty to defend our title and fee simple, are derelict in their duty, evidenced by the fact that some entity claims to have a claim against our property, and said insurance company is not defending our interest against these liens, encumbrances, and defects of recording. The closing agent has failed to execute his duty in properly recording the good faith purchase agreement between the grantor and us and delivering to us the legal title. Closing agent's failure to execute contractual duties has allowed errors and omissions to exist in public and private records as to whom has the right to hold the legal title to said land and property. It's because it has never been closed. These errors and omissions have left us as tenants paying rent in the form of property taxes to an unknown claimant of said legal title, enforced by usurpers of township, city, and county office who have not sworn on oath nor filed for record the proper oath and bond for the office they claim to hold. They're not taking the proper oath. And if it looks like the proper oath, if you were to go look when it's recorded, right, and read how they're supposed to be recorded, usually it has to have like the seal of the mayor, the seal of the clerk. It has to be double sealed. You have to have two, it has to be a quorum. Two people have to have signed it. Plus the guy taking the oath. Okay, so when these officers are questioned, they conceal the truth. When questioned further, they rely on false and misleading statements. When caught in a lie or concealment of fact, they threaten arrest by calling on other usurpers of public office to enforce their fraud. Let's just call it what it is, just a bunch of fraud. People pretending to have an office are usurping the powers of a state office and they haven't taken the proper oath. That's called usurpation of office. Finally, we are victims of identity theft, as mail with no return address is being sent to a true name and an unknown postal address for false pretenses. This vitally important mail ends up as lost mail, never delivered. The post office has informed us that our mailing addresses come from the county government, and this municipal corporation is concealing our mail from us. Numerous fictitious names and accounts have been created that represent diverse estates cut from the larger estate with the intent of concealing our property and its use from us. So every time you see your all capital name with an account number, that's a smaller estate cut from the larger. It's one of the diverse estates cut from the larger. And this true name, Ritluski, Robert Allen, I believe has a postal address right now. I just don't know where it is. So they very well could be sending mail to them. But I'm not getting it, so it's going to lost mail. Why else do they get 90 million pieces of lost mail a year, at least, down in Atlanta? And if they do it on a postcard, postcards don't have any place for a return address. And there were over 4 billion postcards sent in 2006 or 7, I think, whatever it was I was looking at. It's a lot of pictures of beaches. I don't think so. All right, there's a lot of vital information going by postcard. It should be coming to you, but it's going to a fictitious address or one unknown to you, sits there for 30 days, lost mail, away it goes, down to Atlanta. So let the record show that these are the acts of false accusers whose unchristian belief is a persecution of God's people, contrary to his laws, a disregard of justice, and a violation of the king's peace. We demand an in personam proceeding in equity, conducted under oath, with full proof evidence and sworn testimony to determine the rights, title, and interest in the contested lands and property, the correction of public and private records, specific performance of contracts, returns of securities and their gain, locating our lost mail, and other just remedies as determined by competent tribunal. Right? There's probably a whole bunch of other things we could ask for, right? I'm just going to let them decide what it is. You know, I want the legal titles. I want my securities back, because everything listed on the deed of trust mortgage is a security that is supposed to be returned to you along with its gains when you've satisfied the underlying debt. And the underlying debt is what doesn't exist because they don't have a recorded lien to show it. As good citizens of God's earthly empire, we make your conscience aware of these transgressions, and as you hold the solemn office of magistracy, it being one of the sons of oil, servant of the Lord and defender of the New Testament, to see that his laws are upheld. Date it. I have read the foregoing, swear on oath that it is true to the best of my knowledge and belief. Signature, line, block letter name, telephone number, address, whatever you think you need to give them. But you need to give them a way to get a hold of you. I don't even know you need, I'm not 100% convinced you even need to go to a notary to do this, because I'm saying that I swear on oath that it's true to the best of my knowledge. If they have a question on it, they can call me and put me under oath. I don't know if going to the notary gives it any more power or not, and I'm not saying not to do it. I'm not saying not to go get a certificate of authority, right? I guess my point is, if you're going to go to a notary, go get the certificate of authority too, make it foolproof evidence. And then you would mail this directly to the chief judge's office, and we'll see what they do. So far, not a lot's happened except this one thing where Bob sent one to the chief judge of Maricopa County, and on Sunday, a prosecutor for a traffic case is trying to call him. Well, that's odd on a Sunday. Why, who's ever heard of a prosecutor calling on a Sunday? Well, here it is Wednesday, and Bob's called him on. So Bob called him Monday. Said, well, let's wait till Monday. Call him during work hours. And the guy hasn't called back yet. Here it is Wednesday. Well, what was so important to call on Sunday that he can't call between Monday and Wednesday? There's more than meets the eye. And I talked to Mike in Utah yesterday, and he was down at the federal district court, and he went into the counter like everybody else, asking about putting in a complaint. Said, yeah, you can put a complaint in, $400, whatever it is. He said, well, you mean I can't put one in for free? They talked about doing the paperwork for, being an indigent, but that isn't what Mike was looking for, right? So Mike started looking around the building, and sure enough, he walked down a hallway, and what does it say at the end of the hallway? Chief Judge's office. So he walked into the door that said Chief Judge's office and asked if he could leave a complaint there, and they said yes, and he did, and it didn't cost him anything. Don't know what's going to happen with it, just put it in yesterday. I'm not even really sure what he asked for. My point is, he found a place to go put a complaint for free. It was at the Chief Judge's office. Right? Mail it to the Chief Judge. Don't put it in a frickin' court case. Right? You don't want to have a civil action. You want to have an in personam jurisdiction, and that's equity. And you're going into a court of law, into an in rem action. And in rem, the frickin' defendant is your property. Technically, it's supposed to be a non-confrontational suit. There's not supposed to be an adversary. But they're supposed to have given proper notice. And so the shit they're sending you is not the proper notice they're talking about. They have these very specific, if you go look in foreclosure stuff, very specific affidavits of whatever they're supposed to have provided. And they haven't done that stuff. Right? So they're not following their own laws. You're not going to get a remedy in a court of law. You need to go to equity, because equity will not allow a statute to be used as an instrument of fraud. So they say, and that's why it's so hard to find justice, because once you do, their charade is over. And so whether you were to send this to the Chief Judge of the county or to the Supreme Court of your state, because here in Michigan, the Supreme Court has original jurisdiction in law and equity, which means you can start a case there. And cases in equity are always started as bills of complaints sent to the chancellor. You don't open a court case, you send them a complaint. And finding out that ex parte means the same as can mean the same as property. It can also mean in the matter of. But its English name is a petition. Well, a petition is a form of complaint. It's an equitable, you're looking for an equitable remedy. I'm not looking for a money damage. I just want my property back and its gains, right? They don't need to know what it's worth. It's none of their business. They want you to buy and sell and, take the filthy lucre, and I don't want it. I just want my property back, and I'll do with it as I please. You don't need to know what's in the box that says escrow. It's my box. So that's about it, right? It would be that simple. You got time and got 44 cents? Well, there you go. You losing your property? There you go. Give it a try. Chief Judge of the county, Chief Judge of the Appeals Court, Chief Judge of the Supreme Court, Chief Judge of the District Court, U.S. of the District Court. In fact, that was a thing. If I remember what Mike said, when he walked in, he said, I'm looking, he said, I'd like to leave a complaint here. And so he asked the lady, so what's the name of the court? He said, this is the District Court of the United States. Oh, and he said, not the United States District Court. And he said, no, this is the District Court of the United States. How can I help you? I'd like to leave a complaint. And he did. He found the District Court of the United States. the chief judge of the, nobody wants to believe this, right? The chief judge of the frickin' the district court, federal district court, like here we have two of them in Michigan, the Eastern and Western district courts. The chief judge that's been appointed, lifetime appointment, is an Article 3 judge. And if you take it to his office, instead of trying to open a court case in a civil action, instead of what it needs to be, a complaint sworn under oath, maybe things will be different. You don't need to send them a 50-page book. You just need to point a few things out. They've already got the evidence. The evidence is the court case that you're complaining about, because it doesn't have any seals or signatures. It doesn't have a frickin' sworn complaint. So make it as hard as we want, or we can try and do it easy. I'm all about trying to do it the easy way. So okay, we'll see you guys.